My name is Samiullah. My SRN number is BP0187688. I am a trainee solicitor at a fictitious law firm, Brierley Bond. I have received an email from Jasjeet Chawla regarding surrogacy case on family law. Family law is a body of law which deals with marriage, divorce, adoption, paternity, custody of the child, and other domestic issues relating to non-parental couple. Now I'll be coming to the facts of the case. Jack and Tabitha have been living for the past 5 years. They are not married, but they want to have a child. They have talked to a friend Rupa, who is neither in a relationship nor married. Rupa has agreed to act as a surrogate mother. And there is a surrogacy contract between Rupa and the couple. Rupa has agreed in a contract that she will hand over the child to the couple. Rupa has been impregnated at a licensed clinic using Jack's sperm and a donor egg. The child is due at the end of September. Now Jack and Tabitha would like to have some legal advice regarding the surrogacy case. I will be answering the question given to me by Jack. The first question is, who will be the legal mother of the child at birth? The legal mother of the child at birth is the surrogate mother, which is Rupa in this case. The Section 33 of the Human Fertilization Embryology Act 2008 says regarding the surrogate mother. Surrogate mother is the one which falls within the definition of mother. As said, it will remain the case that the woman who carries the child following assisted reproduction will be the legal mother of the child, unless the child is adopted or the parental order is passed on. Now I'll be moving on to the second question, which is given to me by Jack. That is, if Rupa hands over the child to Jack and Tabitha, what action can Jack and Tabitha take to ensure that they will become the child's legal parent? If Rupa hands over the child to the couple as agreed at birth, the first requisite is satisfied in Section 54, subsection 4, which I will read out to you. Section 54, subsection 4 says, at the time of the application and the making of the order, the child's home must be with the applicant, and either or both of the applicant must be domiciled in the United Kingdom or in the Channel Islands or the Isle of Man. The applicant must have the home of the child, which, as seen in the fact, the applicants are Jack and Tabitha, and they must be domiciled in the United Kingdom or Channel Island or the Isle of Man. Now moving on to another subsection, subsection 3, the applicants must apply for the order during the period of 6 months, beginning with the day on which the child is born. The applicant must file the application during the period of 6 months after the child is born in order to obtain parental order. If they fail to do so, if they fail to file the application during the prescribed period, they will not be able to obtain parental order. The application will be time barred. The surrogate, the legal status of the surrogate of Rupa as the mother will attain finality, and the couple will not be able to obtain parental order. The legal mother, who is the Rupa in this case, can claim the child back at any time. Now moving on to subsection 1, B. The gametes of at least one of the applicants was used to bring about the creation of the embryo. Now, as seen in the facts of the case, Jack's sperm was used to bring about the creation of embryo. Now, we'll move on to section 54, subsection 2c, which says two persons who are living as partners in an enduring family relationship and are not within prohibited degrees of relationship in relation to each other. Now, as seen in the facts, Jack and Tabitha have been living for the past 5 years. They are not married. So, they are in a family relationship. The two persons, Jack and Tabitha, are in a family relationship. So, this condition is also satisfied. The applicants are two persons living in a family relationship. Now, we'll move on to section 54, subsection 6. It says the court must be satisfied that the woman who carried the child and any other person who is a parent of the child but is not one of the applicants have freely and with full understanding of what is involved agreed unconditionally to the making of the order. Now they must freely and with fully understanding, they should agree to the making of the order. Now we'll move on to subsection 8, which says the court must be satisfied that no money or other benefit has been given or received by either of the applicants for or in consideration of the making of the order, the handing over of the child to the applicant, or the making of the arrangement with a view to the making of the order. Now, there must not be any financial transaction with the surrogate mother for the arrangement of the court order or the custody of the child. And we also need to look at subsection 8a in this case, which is an order relating to the child must not previously have been made under this section or section 54a unless the order has been quashed or an appeal against the order has been allowed. Now I'll be moving on to the third question, which says if Rupa does not hand over the child to the couple, can Jack and Tabitha enforce the surrogacy agreement? And what actions, what alternative to court proceeding can Jack and Tabitha take regarding the dispute of care of the child? Jack and Tabitha cannot enforce the surrogacy agreement. Surrogacy agreement as concluded with Rupa is unenforceable, as said in section 1A of the Surrogacy Arrangement Act 1985. Now the alternatives to court proceeding Jack and Tabitha can take is alternate dispute resolution. In alternate dispute resolution, they can resort to mediation. Mediation can be defined as the mediator is a neutral third party which helps to resolve dispute among the two parties by bringing them to a mutually acceptable agreement. Now, this results in out of the court settlement. ADR is less time consuming, less costly, and it helps to maintain privacy. Thank you.